Carly. Like she just introduced me, my name is Ridge Howell, and I'm legal counsel for Native Agriculture Financial Services. And I am leading today's presentation. I'm going to go ahead and share my screen. We are talking about legal risk management and specifically farm transition and estate planning. My goals for this presentation are one, to make it pretty approachable. The legal aspects of estate planning can be complicated, but I want to make it approachable and kind of give you an overview of what your options are, and the different types of estate planning tools that are available to you, which can kind of just line up with your own operation and your own individual needs, based off what your goals are. So, um, farm transition, looking at the options. It can be overwhelming, but the first thing we want to look at is where are you and where are you wanting to go? This is the first goal of transition planning because it can look so drastically different for every farm, and really every individual. So how do you figure it out? I think the best place to start is by communicating with your family and any other potential heirs that you might be dealing with. We're continuing to look at the options. So, what should a person consider when they are considering an estate plan? Possibly the largest, especially for farming operations, are tax consequences. There are different types of exceptions, state and federal law, different types of taxes that all can be affected by what type of estate plan you put together and how you plan on transitioning your assets, whether they're real property or something different, once you are ready to make a move on your estate. Other considerations are financial resources of the next generation. In a farming context, this can look a lot different based off of children and whether or not you have children that are wanting to stay on the farm, or maybe those that have gone off farm and maybe have different financial resources than what you currently have on the farm. You'd want to think of the timeliness of a farm transfer. Unfortunately, whenever we're dealing with topics that kind of surround death, we have to think about the fact that sometimes sickness can come on quickly. Your family situation can kind of change at the drop of a hat. So you also want to consider how much time you have whenever you're thinking about an estate plan. And then finally, how involved does the transferring farmer want to be in the operation of the farm? Is this a situation where you are truly retiring, or are you maybe just passing on most of the management operations to a farm manager or potentially a child? So all of these different considerations kind of go into what you want your individual estate plan to look like. Estate planning for your operation. Estate plans can be simple or complex depending on the size of your operation, the composition of your estate, your family situation, and any business situation that you're a part of. No two families have precisely the same set of circumstances, but there are some basic estate plans that most people follow. The ones that we're going to talk about today are one, the option of no plan, two, the options around joint tenancy distribution schemes. We'll talk about wills generally, and then we'll also talk about trusts. This brings us to the 5 Ds. Anytime I see this, I have a little bit of PTSD from when I was at law school because this was drilled into our heads, but it was drilled into our heads for a good reason. The 5 Ds are important, and it's things that we typically don't want to think about. Many producers fail to do adequate farm business transition planning, which really becomes an issue when we reach one of the 5 Ds: death, disability, divorce, disagreement, or disaster. 45% of those 55 or older do not have an estate plan. And without a proper estate plan in place, one of the Ds could lead to land or even total farm loss. So, what type of estate plans are available to you? A common plan, though it's not recommended, and if you take anything away from the presentation today, I hope that it's no plan is not a good plan. So a common plan, though not recommended, is not to plan for your death and your estate. No will is written, and little attention is paid to property ownership, estate distribution, or taxes. Each state generally has a succession law that dictates how assets are distributed if a person dies without a will, which is referred to as dying intestate. Accordingly, if you die intestate, state law will determine who will inherit your property. In most cases, property, whenever it's determined by state law, will be divided in some manner between your spouse and children, except for property that's held jointly and for life insurance. Joint tenancy property will go to the surviving joint tenant. So whoever owns the other portion of the property you have, it would automatically go to them. And life insurance goes to the named beneficiary on the life insurance documentation. Um, no plan or intestacy, so deciding by state law, can become even more complicated if there are multiple marriages involved or if you have children from different spouses. A state's plan, so the intestacy scheme of a state, creates issues because they're generally complex and not flexible. So it doesn't change as your family and financial situation changes, and it may provide inadequate income for their surviving spouse. This approach often results in unnecessary taxes and other consequences.
Hey, Ridge, before
Yes.
you move forward, there is a question in the question box,
Okay.
and uh, I I believe, Miss Kathy, if you can correct me if I'm wrong. Uh, she's wanting to know if farm and homestead kind of could be interchangeable.
Like if referring to your operation as a farm or a homestead, yes. Yes. And if you have more specifics on it, feel free to ask it or put it in the chat box for the end. Harley, you'll have to help me keep an eye on the chat box because I can't see it from my presentation screen right now.
Okay, I can do that.
Thank you. So continuing on joint tenancy, another common plan is to put all property into what's called joint tenancy and let the surviving tenant inherit all the property. So how does this work? What does it look like? Generally, this joint tenancy schemes happen between spouses. Let's say a husband and wife own a piece of property jointly. Their name is on the title of the property, or both their names are on the title of the property. Both of their names are on their banking information if there's some type of loan or a note. So essentially, those two individuals own that piece of property as joint tenants. So under joint tenancy distribution, you could own something as a joint tenant and then just let it uh, be passed on to the surviving tenant at death. However, this can get complicated. So when does joint tenancy work? It can work well upon the first death of a spouse when the estate is small and when the husband and wife hold all of their property in joint tenancy. Many couples use this joint tenancy ownership of their personal residence, personal vehicles, their checking account, and possibly even things like livestock. So when somebody owns something as a joint tenant, when one spouse dies, the surviving spouse automatically gets full access to the property without any kind of court delay. But what are the downsides of joint tenancy distribution? Well, one, if the estate exceeds the federal or state exclusion amount, and it's a second death, this approach can cause huge tax consequences. Two, holding property in joint tenancy with children can cause other problems if the or if the child dies first, or if the child gets involved in bankruptcy, divorce, or some other kind of adverse legal action. For some people, no plan really does look like joint tenancy. For instance, before I went to law school, my parents did not have a will. However, in the case of death, almost everything naturally would have flown to my surviving parent as they were joint tenants on almost all of their property. There is one exception in their situation, which is my father's allotted Indian land, which my mom, her name was not on the title to that. But for potentially all other circumstances, joint tenancy would have worked for them. But again, this can be pretty fact specific, and it's also really specific based off your situation. Like I said a little bit earlier, things might get complicated if you have a child that dies, or if you have a spouse that dies and then you decide to remarry. So what is the takeaway from joint tenancy distribution? A joint tenancy plan can work well for families with total net estates under the federal and state applicable exclusion exemption amounts. That's a mouthful. However, joint tenancy does not protect your assets from adverse actions such as lawsuits. Joint tenancy does not avoid the probate process upon the second death, and joint tenancy will not protect assets from long-term care costs paid for by Medicaid. So while it maybe is a step better than not having any plan in place, there are still a lot of things that you're not going to be able to tailor with a joint tenancy distribution plan. So it's something that I would caution against, although it can work in some situations.
There is, in reference to the tax burden in joint tenancy, is the state of the residence or the federal tax the bigger concern?
It depends on the state. So there are going to be some states that are going to be have a value that's higher than the federal tax limit, and some states that are going to be less. But because all of these laws are state specific, it's just going to depend on what state you're in at the time of death. Any other joint tenancy questions before we move to wills?
That's all I see.
Okay, awesome. Feel free to pop up if you do have any. So, looking at wills, first question we have to ask is, what is a will? Essentially, it's just a legal document that lists instructions regarding the distribution and management of your assets. A will technically only directs finances with the exception of guardianships. So if you have a child or somebody that is incapacitated in some way, you could set out what you want the guardianship to look like in a will. And a will is generally the first step in the estate planning process. Even if somebody ends up going on to create something like a trust, the process usually begins with creating a will and kind of outlining what somebody wants their assets to look like after death. So who should create a will? Generally, spouses should each have a separate will. A will can be personalized, and there's just a lot of latitude in how you want your individual will to be written and how you want your assets divided. Our first type of wills that we're going to look at are simple or sweetheart wills. Many wills are written which distribute all assets to their surviving spouse, and these are called simple or sweetheart wills. This can be an acceptable plan if the total value of the couple's assets, including life insurance, is less than the federal and state applicable exclusion exemption amounts. In that scenario, no estate taxes would be payable upon the second death. So let's say you have a sweetheart will, the first spouse dies, everything in the sweetheart will directs it to go to the second spouse. Upon the second spouse's death, no estate taxes would be payable on that death. So this is a kind of a step up from what we might think of as a joint distribution scheme, but it's still a simpler version of a will that's kind of allocating things in big paint strokes, if you will. Most simple wills leave everything to the children equally if there is no surviving spouse. However, you can run into issues with simple wills when children are involved. Under both simple wills and joint distribution plans, leaving everything to your spouse gives no protection to the children. Thus, the surviving spouse may spend or lose all of their property, or they may remarry and lose control of your estate, leaving your children with no part of your estate. Additionally, passing the assets equally to all children may not achieve your goals for passing on your farm to the next generation. So with that in mind, we've got what we might call a simple will or a sweetheart will. Now we kind of turn toward the more complex will, which there are infinite number of ways that you could create a complex will, but generally they are used to create a trust or a structure for estate planning purposes. Couples who have divided their property ownership somewhat equally between themselves often use complex wills. Upon the first death, this plan uses a will to direct assets to the children via a trust with life use to the spouse. So, under a complex will, a trust is created for the child or the children. However, the surviving spouse has access to that trust during the duration of their life. So this is used when combined estates are valued over the federal and state applicable exclusion exemption amounts, and when definite provisions wish to be made for the children. So whenever you're above that threshold, or if you want to be really specific in how you divide assets between children, a complex will is probably going to be a better bet for you. It can be kind of complicated because it's a complex will that creates a trust. But generally, we just think of it as a complex will. Um, in a complex will, any assets such as stocks, bonds, life insurance proceeds, mutual funds, real estate, or cash can be set aside for the children. Willing a portion of the estate to the children protects the children in case the spouse remarries or otherwise consumes the estate prior to death. It also prevents this portion of the estate from being taxed at the death of the second spouse. However, this process does not necessarily protect the children's inheritance from lawsuit or other adverse actions. Special trust provisions must be included if you wanted to add that kind of protection in. It also doesn't avoid the probate process upon the second spouse's death, which you do avoid in the case of a true trust, which we'll talk about in a few minutes. In addition to the simple and the complex will, we also have the holographic will. This is very specific to the jurisdiction you're in, but it generally gets you outside of the requirements of witnessing and notarization of the will. So generally under any other will, regardless of what state you're in, you have to have the will witnessed, typically by non-beneficiaries of the will, and notarized in order for the will to be valid. This can lead to huge timing issues, especially in emergency situations. In these scenarios, a holographic will can provide a family with some ability to make transition plans, even if it's more limited than a simple or a complex will. A holographic will is simply an entirely handwritten will that is signed and dated by the testator or the grantor, so the person who's writing the will. Crucially, the holographic will does not have to be signed or notarized by witnesses or a notary, so it can be created really, really quickly.
So, how does having the farm listed as a business entity affect writing a complex will?
That's
Does
a
it make a difference if family members are put as business officers, not necessarily owners?
um, generally, one, I would tell you come back for our business entity presentation because we'll go a little bit more into entity formation and how we split that up with estate planning. But on a high level, the business entity is another one of your assets that you're going to divide like anything else. So let's say hypothetically, you own a house, a farm vehicle, a business, and a farm. And let's say the business is a farming business. Under a will, if you own all of it, you could direct that business to be, you know, you could transition that business to anybody or any entity that you selected underneath the terms of your will. However, whenever things get more complicated, so if it's a business or a farm that has a ton of assets, a ton of value, or if there are several individuals that own a portion of the entity, a lot of times a trust is going to be better fit for you because it's going to allow you to either A, make more decisions, business decisions in advance, or B, it's going to protect your assets while also allowing you the ability, if it's a revocable trust, the ability to kind of change how your assets are organized within the trust. I'm not sure if I totally answered it. I think the takeaway though is you can divide your business entity through a will or through a trust like any other piece of property you have. It just might be more complicated based off things like other business partners, the size of the company. If you've got children and some of them are going to be involved in the running it or the management of the country and some of them aren't. All of those things kind of inform whether or not a will or a trust would be better, and then what kind of provisions you'd want to include. Okay. And again, please ask any follow-up questions if you have any, or if that explanation confused you more. Um, Back to holographic wills, they are not valid in every state, and you may run into issues validating a holographic will during probate, just because since there isn't a witness or a notarization requirement, there's a lot more opportunity for things like fraud to come into play. So proving that the will is valid and that it was, the intentions of the person who created it can be kind of complicated. So it differs between jurisdictions, but the following states accept holographic wills in some form. And we'll send this presentation out afterwards, but these are the states as of 2025 that accept some type of holographic will. So what are the cons of the holographic will? You've got limited ability to direct transition, so it may be complicated in scenarios with multiple beneficiaries or when there are complex business ties. That kind of takes us back to the question you just asked, Harley, about wills and what happens if you own a business entity. A holographic will, although it may provide you some protection in an emergency situation, you would not want to use a holographic will to try and divide or direct how you want your business to who you want it to go to after your death, just because they're generally about the most simple version of a will that you can create. And they've got the most opportunity for issues with validation. So you've got risk of legal challenges due to lack of formal witness or notarization. You've got increased vulnerability to fraud or claims of lack of testamentary capacity. So if somebody is in a state where they're not, their mental capability is impaired, that could be a claim against a holographic will in court, and it can be invalidated if not executed according to state law. This is maybe the biggest takeaway from holographic wills and why it's important, if you intend to create one, to know exactly what your state says about them. Since they are the least secure version of a will, any kind of variation from what state law, from the requirements state law puts on holographic wills, is likely going to lead to it being invalidated in court. So, what are the good and the bad of wills? We'll look at the pros first. A will allows you to control property until death. You can direct who gets property through a will. You are allowed to select your executor and any guardians if you have young children in question. And once property is distributed, the will is no longer needed. So after, post-death and after the property is distributed, the will is complete. The downsides or the cons of having a will: you have to probate it, which can be a lengthy and even expensive process. Excuse me. It is easily contested, especially in the case of something like a holographic will, even if you include a no contest clause within the will itself. It takes time and it's a public process. So even after death, the will has to be probated, and that information is largely open to the public, and it's state specific. So while, for instance, on this call, we can kind of give an overview of what creating a will is and the different types of wills that are available to you, we can't actually give specifics because everybody here, or most people here, are from different states. So the standards that you have in your state likely would not apply to your neighbor who's in a different state. Any questions on wills before we move on to an overview of trust? Okay. If not, that takes us to trust. So trusts are another succession planning tool. A trust can provide a means to hold and manage your property. You could think of a trust as a bucket in which you place all of your assets. While trusts can be customized to the person, most trusts have four basic elements: a trustee, the person who oversees the trust, the actual property, the beneficiaries, so those individuals who benefit from the trust, and the instructions and guidelines to overseeing the trust. They can be used for many purposes, including management of assets for minors, elderly persons, or handicapped persons, and they also protect from lawsuits or other adverse actions. Trust may be used to leave someone a limited interest in property or to transfer a farm business. They also may be utilized to reduce the size of an estate or to minimize estate and probate cost. I want to go back to a couple questions ago when it was somebody asked about how you basically plan for transitioning a business when your farm is a business. A lot of times a trust is going to be your best route just because it gives you the most ability to tailor what you want your operation to look like after it leaves your hands. Unlike wills, trusts as an estate planning tool are not for everyone. People who should consider using a trust, I've got a few different examples listed below. It could include those with estates approaching the federal estate tax limit. For 2025, that is 13.99 million for an individual and 25.84 million for a couple. So if you have an operation that you think the value of it is going to be over that, a trust would 100% be the best option for you because it's going to allow you some protection from tax consequences. Those with children or a disabled family member should consider trust, especially if that family member or child is going to need care, if the parents are going to unexpectedly pass away. So in situations where, somebody needs round the clock or pretty frequent care, a trust would be a good option, especially for peace of mind, just because it allows the individuals creating the trust really specific ways that they can pass off things like how to care for family members after they're gone. And trusts are also good options for family members that can no longer manage their own affairs, such as an elderly parent.
Okay, if I own two rental properties in
Mhm,
two different states, will I
mhm.
need to put each rental property into two separate trusts? Shall I place my third property, the house I live in, on a separate trust as well? The house we live in is our urban farm. Shall I have an LLC be my renter to the house's trust?
So I'm not going to be able to give you a direct legal answer, just because it is 100% fact specific and also specific to what you want your operation to look like after you're gone. That being said, uh, while you could have different like arms of the trust that you could put them in, I would say generally people would not put them in separate types of trust. It would be a trust with different types of management priorities or guidelines that are included for specific purposes. Um, this could be affected by state law. So if you've got property or businesses in two different states, I would want to look at state law intestacy laws or testacy laws for both of those states before giving you a full answer. But just on the description, my gut is that a trust would definitely be the best option for you as far as an estate planning tool, but I can't get too much more specific outside of that without sitting down with you and looking at it. Any others? Okay. Um, Several types of trust exist, but there are two main types, and this is high level, so there's really more than two main types, but there are two types that are most commonly used, I guess I should say. They are testamentary trust and living trust. So a trust for after death and a trust for during life. Testamentary trust, which we discussed during complex wills, is a trust that is created by the grantor, the creator of the trust, as part of a last will and testament. The trust is established after the grantor's death. That's a crucial piece. It doesn't exist while they're living, it's established after death. In the will, in a complex will, a grantor can create separate trusts for each beneficiary, splitting assets equally, or a family trust that allows assets to be distributed based on need or some other factor. This again kind of goes back to that question that Harley just asked. Trust or wills and trusts generally are super flexible. So there's not really a one size fits all for even a farming operation. It's just really going to depend on what you want your operation to look like, who it's going to go to, and how complicated your ties, whether they're business or family, are. Um, so yeah, in the will, you are creating those guidelines for how you want your trust or trusts to be split up. Living trust. Living trusts are established during the grantor's lifetime and may continue after death. A living trust can either be a revocable living trust or an RLT, which means it's changeable, or an irrevocable trust, which means after the trust is created, you can't change it. Reasons to consider a living trust. Living trusts avoid probate costs. They allow for the transfer of property in different states. They allow for managing of assets if you become incapacitated. A good example of that, there are situations that I know of where somebody is diagnosed with early onset dementia and they end up creating a trust pretty quickly afterwards, while they are still in, a healthy state of mind that can then dictate how their property is utilized, used, or not used after they do become incapacitated or as the disease progresses. Reasons to consider a living trust also, you should consider it because it distributes property to the beneficiaries faster than the probate process. So whenever you've got a living trust, death doesn't affect it near as much. So whenever somebody who created the living trust dies, there isn't necessarily need for a long process because it's already exists. You're not having to go to court to prove it or to prove the validity of it. Reasons not to consider a living trust. Of your options, this is about the most expensive to create and update. It requires a lawyer from the first step to draft trust documents and then also to administer the trust after it's created. For a lot of people, expenses can outweigh benefits. This is why it's important to take into account state and federal tax requirements. A couple of slides ago, we talked about the federal tax number being like 13.9 million. If you're not approaching that or near that, you might want to consider whether or not a trust is good for you just because they can be really cost prohibitive. So essentially, expenses can outweigh benefits. Many couples, however, use the revocable living trust as their primary estate planning tool, especially whenever they have businesses. They choose an RLT because assets in an RLT pass outside of the probate process, potentially saving thousands of dollars. They can set up joint or separate revocable living trusts during their lifetime by placing all of their assets into the trust. And by placing these into the trust, it protects the assets from any adverse actions like lawsuits upon the death of both parents. Irrevocable trust. These are also established during the grantor's lifetime and are used to reduce the size of your estate, thus reducing taxes and/or to establish a trust for beneficiaries. The irrevocable trust removes property irrevocably from your gross estate. So like I said earlier, if you create an irrevocable trust, once it is created and running, you can't do anything to change the property that is already placed in the trust. So once it's in there for good. Placing assets into an irrevocable trust is final. They cannot be reclaimed, and the trust conditions, nor can the trust conditions be modified once established. It is a true irrevocable trust. So basically, they can be a great opportunity for, especially for high net worth individuals, but a lot of consideration should go into creating an irrevocable trust before you actually do it. So what are the good and bad or the pros and cons of trust? Looking at the pros first, a big one is you eliminate the need for probate. Uh, that eliminates cost. It eliminates a lot of times heartache for the family afterwards. Nobody wants to go to court to prove that a will was valid or that, their loved one intended their assets to be divided in the way that they intended for them to be. So basically, you can just eliminate a lot of that heartache by creating a trust because you don't have to probate it. Trusts are not public. So, during the probate process with a will, everything is available to the public. That's not the same scenario with trust. So if you are concerned about privacy, that could be a great option. They are difficult to contest. So it's harder to, make a claim that a trust is not valid. And you do not need a guardian to hold assets for minors. The trust does that itself. What are the cons of trust? You potentially have trustee fees, especially in large trusts. The individual who oversees the trust, or the trustee, could have a lot of responsibilities, and the guidelines could be complex, which in some scenarios ends up with a pretty large salary coming out of the trust for the trustee. It adds complexity to asset management. You have a greater need to coordinate with other estate tools because a trust is kind of all encompassing. And even when you create a trust, you still need a will. That complex will that we talked about earlier really is the basis for a trust. So even if you were hoping to avoid that piece of it, you still have to at least start out with creating a will.
Okay, so do you suggest a IT as a added safety net for having an agro-tourism operation on your farm?
Um, Again, I'm hesitant to give too secure of an answer just because it's going to be really fact specific. I would say generally with irrevocable trust, I want to think really, really, really long and hard about what I'm putting into the trust and how my family situation might change, not over the next 5 or 10 years, but over the next 30 to 50 years. Um, if agritourism is a unique area of the law because it's a form of tourism, so you've got different safety concerns than somebody who just operates a farm might have. For that reason, there could be an argument made that an irrevocable trust would be a safe option. But uh, I think my gut instinct is to really pause and reconsider, and make sure that, get a lawyer and talk with them before trying to go down that path just because it's one that you can't come back from. But agritourism might be one of those areas where an irrevocable trust would be really well used or utilized. Any other questions from that?
That's all I see for now.
Okay. So those are the kind of pros and cons, which takes us to our final slide, which is just a summary. And it kind of the highlights that I want you to take away. The first one being that no estate plan is a plan. Deciding not to create an estate plan is a decision, and it is a type of intestacy plan, but one that might come with unfortunate consequences. Again, especially in the case of farms, especially if you've got more than one type of business on your farm, no estate plan could end up in some really bad, could lead to some really bad circumstances for the beneficiaries of your estate. Success with estate and transition planning requires communication. Even on some of the questions y'all have asked me throughout the last hour, you can see that I'm leery to give you a full answer, and that's just because estate plans are about the most fact-specific thing that you could create because they are totally individual to every person that's creating it. The estate planning tools discussed are only helpful once you know what your goals are. So go talk to your family. Um, it can be hard to create a plan like this in a vacuum. And a lot of times you're going to need to speak with those closest to you to decide not only how you want to divide up assets between yourself and potentially your kids or loved ones, but you also want to know what the future of your operation is going to look like. A lot of families go into a conversation about estate planning thinking that they are headed down one path, only to realize after they really started communicating that they need to go in a different direction. So it's hard to get a full grasp on what you need without talking to those that it affects. So, in conclusion, speak with those that you need to and those that are going to benefit from your estate, because they will inform how you want to plan. That is the end of the slideshow. So I think we can go to any other questions that y'all might have.
And I'm gonna give everybody the ability to talk so that they can ask their questions. Miss Crystal raised your hand. I think you should have the ability to speak.
Thank you. Hello, thank you so much for the presentation. Can we reach out to the presenter? I'm sorry, I lost your name here. And ask you our family questions then?
You are more than welcome to reach out to me. My name's Ridge Howell, by the way. If y'all do have questions, I won't be able to give any actual legal advice. So I can't advise you on how you should go or, what's going to be the best option for your specific situation. What I could do is point you to things like, if you've got a really complex plan that sounds like a trust would be needed versus a will, that's something that I could help out with. And I could also, potentially point you in the direction of legal resources that could help. But I won't actually be able to, kind of parcel through all of your stuff and put together a type of plan.
Understood. Thank you.
Of course. I'm going to put my email address in the chat right now.
And Miss Sherry, I see your hands raised, so feel free to ask your question whenever. Maybe.
I'm hearing something, but I can't tell if it's a question or if it's background.
I think it's just background.
Okay.
Yeah, if any of you guys have specific questions, just feel free to unmute yourselves and oh, I see a no, I don't. A question. Arnold, I see your hands raised. Feel free to ask.
Yes, I have a couple questions here. I have a small farm that my son and I operate together. I have everything in a joint tenants because there's no wife. I have a couple other children, but they're well taken care of. I'm just concerned about the tax consequences. You know, I have everything in joint tenants and that, and I'm just not sure about everything else. I'm 82 years old. He's 45. I'm just not sure how to handle everything.
So tax consequences are gonna, uh, I would have two things in mind. One, whatever state you live in, what their state laws are on, as for instance, estate taxes. The other thing I would have in mind is you said you are leaving, you've got more than one child, but you're leaving it to a child that maybe needs the resources more, or the other children are better resourced. Um, in that scenario, one thing you would want to consider is any possibility that one of the other children might contest any property that is transferred after your death. Just because, like we talked about some during the wills portion of it, or during the wills and trust portion of it, under a joint tenancy distribution plan, if there are children and if you are leaving them varying amounts, there's the opportunity for that to be challenged. So it could be totally fine, and it could be fine on the tax portions of your estate, depending on the size of your estate. But at least with joint tenancy distribution, you just want to keep in mind that it could be legally challenged in court.
Okay, thank you, Ridge.
Of course.
There's a one in the chat, Ridge. It says, will a trust protect your land from children's ex-spouses or divorce proceedings?
Again, that's going to be, I don't know that I can give a blanket answer because it's going to depend on what state you're in and when the trust was created. So if it was created prior to marriage, during marriage, after marriage, etc. Generally, there would be protection if the trust, you already had the trust pre-marriage. So if, you know, it wasn't something y'all created together, or if you are the beneficiary of a trust. For instance, if your parents had a trust and you are still receiving benefits from them, if that land was part of it, it would be protected. But without knowing more about the specifics around how it was created, I don't know that I can give a full answer. So potentially, it trust, if it's written so, they could protect you in a divorce proceeding, could protect your assets. These are good questions. I hope it's y'all see the law around this is there's some basic, you know, principles, but then there's a lot of gray area that is kind of filled in by location and law.
Miss Kathy, we do see your hand raised. We'll get to you in just 1 second. There is one more question. Do you have a referral to start trust fund in Texas?
I have referrals around the Dallas or the Amarillo area. So if you're around one of those two areas, I've got attorneys that I know, you know, reputable attorneys that do estate work.
It says yes, Dallas.
Okay.
So,
Yep.
Miss Cynthia, Ridge's email is in the chat section. If you have the ability to send him an email, he can connect you.
And I'll throw it in there one more time.
Okay, Miss Kathy, you're up next.
Just want to make sure, can you hear me okay?
Yes.
I can.
So I have a VA loan on the house that I'm in, that it joins 7 acres that I'm calling a homestead, possibly a farm. And so this question is related to a will or an estate. If there's still a debt on the property that I'm living in, but not the farm or homestead, can I stipulate in the will something to the effect of first right of purchase, so that this property that is, again, could join property line wise to the homestead or the farm. Can I have some means of allowing my family to purchase that? Because I don't think I can directly like give the property to them with this VA loan. I don't know if that makes sense.
I'm not totally sure. If you want, this sounds like something I'd have questions about, but probably don't want to ask right now. If you want to follow up with me on a call, I might be able to give some more specific information.
I appreciate that. Thank you.
Yep.
Mr. Jerry, would you like to go?
Sure, yes, ma'am. Thank y'all both for doing this. And I was wondering about transfer upon death deeds versus revocable trust and tax ramifications of either. Over.
I'm probably not going to have super specifics on tax ramifications because it's going to depend on your size of your operation and where you're located. Transfer on death deeds are one of the easiest and most sure ways to transfer property on death. Similar to some types of wills and trust, they come into play the second somebody dies. So if you've got what's called a TOD, transfer on death deed, set up, for instance, with your bank, it's automatically going to transfer upon death. They're also going to be much, much cheaper to create and then also update if they needed to than a trust. I'm not, like I said, I'm not sure on the tax question, which would be better. My gut is a trust is probably going to be better just because generally trusts have the best options for avoiding tax ramifications. But that's just my gut and not, not something that I could necessarily back up. So I would say transfer on death deeds can be really, really great, especially if you're, not transferring gobs of, crazy amounts of land or assets. Those are great options.
Can TOD be applied?
Can TOD be applied to?
That's what I got right now, Miss Kathy. Oh, to appeal? Oh,
Can-
can TOD be appealed? I can't read. I'm sorry.
Can TOD be
Appealed.
I don't want to give a hard answer because I'm not positive. My memory is somebody could file a lawsuit and argue against it, but their transfer on death deeds are usually made between two parties in a right mind, with typically something like a bank as a third party or the third party in the agreement. So, a lot of times when we're thinking about appeals, we're thinking about the validity of a will or a trust. So whether it was properly created according to state law, and those concerns aren't quite as present with transfer on death deeds or transfer on death documents, just because they're created during life by the person, with others that are witnessing it. But that's probably about as specific as I can go on it.
Does anybody else have any questions? Okay, seeing none.